Good afternoon. Thank you for being here. My name is Aista Zalapuga. I'm the editor-in-chief of the Notre Dame Law Review. Welcome to the Notre Dame Law Review's Federal Courts Symposium on the nature of federal equity power. Before we begin, please note that first, no photos, videos, or audio recordings are allowed. Second, the keynote will be followed by a question and answer period. You're welcome to submit questions by scanning the QR code on the cards in front of you. We are honored to have as our speaker, Associate Justice of the Supreme Court of the United States, Amy Coney Barrett. The current volume of the Notre Dame Law Review marks the 25th anniversary of Justice Barrett's tenure as executive editor of the Law Review when she was a student here. In that role, Justice Barrett laid the foundations for the Federal Courts issue, which is one of the Law Review's 5 annual issues, and dedicated specifically to topics in the area of federal courts, practice, and procedure. It is my honor to welcome Dean Marcus Cole of the Notre Dame Law School, who will introduce Justice Barrett. Dean Cole.
Thank you, Aista. Thank you all for being here, and welcome to Notre Dame Law School. I finally get to introduce Justice Amy Coney Barrett. And I say finally because there was a moment about 18 months ago where I thought I might have a chance to introduce her to a group of people who wanted to meet her. They call themselves the Senate Judiciary Committee. But I wasn't chosen for that introduction. Instead, my very good friend, Dean Patty O'Hara, was chosen for that introduction and did a fabulous job, better than I could. But the good news is that I was able to return the bow tie that I bought for that occasion. So you all know the story of Justice Barrett. You know that she was a legendary student here. You know that as a teacher, she's a legend here at Notre Dame, having won the teaching award at Notre Dame 3 times. And in fact, I think they enacted term limits for her to keep her from holding the honor permanently. But what you might not know about her is that she was, in fact, as a student, 25 years ago, the executive editor of the Notre Dame Law Review, and we are here today because of the movement that she started by creating the federal courts issue of the Notre Dame Law Review, which is now, I'm happy to say, the Notre Dame Law Review is the 7th most cited law journal of any kind in the world. And that's a testament to the legacy that she left us and the students that have followed her. So without any further ado, I'd like to introduce the 103rd Associate Justice of the United States Supreme Court and the 114th Justice of the Supreme Court, Justice Amy Coney Barrett.
Thank all of you, and thank you, Dean Cole. It's really good to be home. When the Law Review extended this invitation, how could I resist? February in South Bend. But it's speaking at an academic symposium, which is a slice of my old life. I'm here at Notre Dame, which I dearly miss, and talking primarily to students, which is something that I love to do. So in all seriousness, I am very happy to be braving the permacloud and the freezing cold to be here with you. So the Law Review staff, with the help of Professors Bray and Miller, have put together a remarkable symposium and a surprising one. They told me last night that this is the first ever symposium on federal equity power. Is that true, Professor Bray? And a bit of a challenge to deliver a keynote address about the federal equity power, I will say. Because let's be honest, at first blush, the topic of the federal equity jurisdiction sounds like one only a law professor could love. It involves the merger of law and equity, the court of chancery, thousands of years of history, and none of this is known for keeping law students, much less anyone else, on the edge of their seats. But take a step back. If you consider it more broadly, the relationship between law and equity is of interest to us all, even to non-lawyers. At root, it's about the tension between the demands of the law, which constrains, and the demands of fairness, which is flexible. That tension permeates almost every area of our law, and it's particularly acute in the context of the federal courts, which are courts of limited jurisdiction. For the non-lawyers in the room, that means they have limited authority to act. Here's an anecdote to illustrate my point. So last summer, I spent an afternoon with a beloved aunt. She and I see things, many things differently, but we're very, very close. And she's not a lawyer, but she started following the Supreme Court closely after I joined it. And one of the things she said to me that day is that she was disappointed in our decisions. Because she said, these decisions from the court are driven by legalities, but I thought the court was supposed to be about dispensing justice. And instead, you guys are just caught up in all of this law. I get the sentiment. When we think about courts, when we think about doing justice, and hopefully courts are synonymous with doing justice, we don't exactly think about opinions on standing or sovereign immunity. Our thoughts are much more likely to drift to stories like the story in the Old Testament of King Solomon and the two women who claimed the same baby. In a brilliant, if high-risk strategy, Solomon decides that, he correctly judges, that if he says that he will divide the baby in half, the woman who is the true mother will step back rather than see the baby die. And fortunately for the baby, Solomon was right. Because he managed to crack the case, the Old Testament memorializes this as one of the examples of Solomon's great wisdom. But note that Solomon's wisdom is something that came from within him. He did not consult principles of tort law, and there was plainly no limit on his remedial authority. And it's this wellspring of inner wisdom that renders Solomon one of the great lawgivers of history who appears on one of the friezes in the Supreme Court's courtroom. Deep down, anyone mired in a legal dispute or any kind of dispute desires that it be resolved according to principles of fairness. To have a judge who pierces the niceties of the law to do what's equitable. That's the sentiment that my aunt was expressing. But of course, the federal courts are not staffed with armies of Solomons. And those who framed and ratified our Constitution in their collective wisdom deliberately checked the authority of federal judges to be free-willing dispensers of justice. So consider what James Madison said in Federalist 51. If men were angels, no government would be necessary, and if angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. Judges, I'm sorry to admit, but no, my family would agree, are not angels. And so in our democratic republic, judges do not function like some of the judicial greats who appear with Solomon on the walls of the courtroom in the Supreme Court. That's a group that includes Hammurabi, Moses, Confucius, and King Louis IX. And as with Solomon, wisdom, the ability to discern the just result, resided within them, either through their own talent or in some cases through divine inspiration. In the case of these judicial greats, the law and the person were intertwined. Yet that's not how it works in our democratic republic, and rightly so. Federal judges do not dispense justice solely by their own lights. We are a government of laws, not of men or of women. As Tom Paine put it, in America, law is king. Federal courts are constrained by law that mostly emanates from somewhere else, like the Constitution, legislation. Plus, when it comes to adjudicating disputes, federal courts cannot take all comers. And that's a distinction between us and Solomon and his companions. Our jurisdiction is limited so that we can only exercise the power that we've been given. But, and if there were no but, there would be no symposium today, the federal courts have been given equitable power. Equity is concerned with fairness and justice, and it's a tool that federal courts have long used, and other courts, to right wrongs when there was no adequate remedy available in law. Article 3 of the Constitution provides that the judicial power of the United States extends to cases in law and equity. The Judiciary Act of 1789 acted on that grant right away, and it gave federal courts jurisdiction over suits in equity in addition to suits at law. So at this point, you might have whiplash, because I just finished emphasizing that federal courts are constrained by law, and now I'm reading you a provision of the Constitution that might sound to you like federal courts have jurisdiction to go forth and adjudicate cases in fairness. So which is it? Restraint or flexibility, hard and fast rules, or equitable principles? Well, it's both. And even though these concepts are admittedly in tension, they do coexist in Article 3 and in our law. That tension between them is reflected in one of the central debates about the federal equity power. How does it fit with the principle that federal courts are constrained by law? Can federal courts just make up the rules when they hear suits in equity? Or do the rules come from someplace else? Now, before we launch into considering these questions, I want to emphasize that the equitable jurisdiction of the federal courts is not a power to do what is just. It's a specific branch of the law, so it's not a general freewheeling grant, as you might fear just from hearing the language, that federal courts should just go forth and adjudicate cases as they see fit. Equity is a specific branch of the law, and a fairly technical one at that, and that's what this symposium is focused on. Now, I'm going to give you a bird's eye view of it, but the room might clear out if I devoted this talk entirely to the ins and outs of federal equity jurisdiction and practice. Sorry, Professors Bray and Miller. So instead, I'm going to use the equity jurisdiction of the federal courts to address important themes that run throughout all the law of federal courts. One theme is the one voiced by my aunt in that conversation last summer. And that theme is that the law can be wooden and harsh, so federal judges should have the ability to soften it, to do what's fair even if the law ostensibly requires a different result. On the other hand, a concern runs in the opposite direction, that judges who aim to be fair are throwing off the constraints of the law in favor of exercising a discretion that is essentially anti-democratic. So when you look at this tension in Article 3, you can describe it either as a love-hate relationship with equity or a love-hate relationship with law. It just depends on your perspective. So this afternoon, I'm going to address these themes, and first I'll talk about it in the specific context of the equity jurisdiction, and then I will shift and talk about it in the more familiar context of constitutional interpretation. So first, the equity jurisdiction. In a general sense, equity means fairness. But in a law school classroom, we might use it in a more technical sense to refer to a set of rights, remedies, and procedures available to ameliorate the defects of the common law. This is a very specific power, this is where it gets good and really interesting, that traces back to the Court of Chancery, which was headed by the Lord Chancellor, the King's right-hand man. And it was known as the Court of the King's Conscience, a place for litigants to come when the common law was too harsh. Predictably, and consistent with today's theme, common law courts didn't like it when they perceived Chancery as exercising too much jurisdiction that eroded the power of the common law courts, and eroded or overrode the legal rules that the common law courts enforced. In the Chancery Court, justice was up to the king, who could be arbitrary in doling it out. This uneasy coexistence of law and equity carried over to America. Equity, given its roots, was associated in the public imagination with royal prerogative, judicial overreaching, and standardless discretion. As one historian put it, it was not easily forgotten that the Court of Chancery was the twin sister of the Court of the Star Chamber, now because both had been born from the King's Council. While equity gave courts the freedom to make up for the lacks of the courts of law, the discretion that it vested in courts could also easily be abused. And so some regarded equity as, quote, a roguish thing. Consequently, many colonies and then states altogether refused to set up courts of equity for fear that they would abuse their power. Americans didn't want a king, and it was the king who had been behind the Court of Chancery and the king who had abused the power. Remember the words of Thomas Paine, in America, law is king. And yet, the need for equity persisted. The common law and its rules were preeminent in America, but there was still a need for the safety valve of equity when the law provided no adequate relief. To make the equity power concrete, let me give you some examples of it so that you know what it is we're talking about. The first is promissory estoppel. An agreement is generally not legally enforceable until it satisfies the basic requirements of offer, acceptance, and consideration. And if there are one else in the room, I apologize if this is giving you flashbacks to your finals. And it's important to maintain those requirements so that everybody knows the rules of the road, okay? The rules of the road for forming valid contracts and when they're enforceable. Yet, equity steps in to do justice and enforce some promises that don't meet those requirements. If I act in reliance on a promise that someone else made, and she reasonably expected that I would rely on her promise, then she can be held to it. In other words, if one person induces another to rely on her promise, well, then it's only fair to hold her to it, even if all the boxes of contract formation haven't been checked. That's an example of an equitable right. Here's an example of an equitable remedy, an injunction. So the traditional legal remedy for a wrong is money. So the wrongdoer has to give you dollars to make up for the damage that he caused. But there are some harms that money doesn't fix. If someone is trespassing on my property by building some sort of structure on it, I don't really want money so that he can essentially engage in a forced sale of my property and pay me and then keep on going doing what he's doing. I want him to stop. What I want is an injunction that will forbid him from continuing the trespass and continuing to erect the structure on my property. Without equity, I could not have obtained that sort of remedy. So you might find yourself nodding along and thinking, what's the big deal? Both of these things are things you learn about in law. They seem fair, and the law wouldn't work well without tools like these. And that is all true. And it's the need for these kinds of equitable rights and remedies that is behind the grant of equitable jurisdiction that made its way into Article 3. Despite the founding generation's unease with some of the discretion conferred by equity, these kinds of needs to address these kinds of problems made equity a necessary feature of our law. Without it, courts couldn't deal with the kinds of situations that I just described to you. Still, because the founding generation was skittish about it, there was a debate about it. It was in Article 3, but still, our courts were structured differently than the courts in England, and anti-federalists in particular criticized the grant of equity jurisdiction on the grounds that it would risk judicial abuse. So Alexander Hamilton in Federalist Number 8 attempts to reassure critics that the equity power had limits. So Hamilton insisted that it built upon a body of well-developed principles regarding the formal and technical distinction between law and equity as the distinction is known and established in several of the states, and where that distinction is exemplified by everyday practice. This passage recalls his more famous general pronouncement in Federalist Number 78, where he said, "To avoid an arbitrary discretion in the courts, it is indispensable that they should be bound down by strict rules and precedents, which serve to define and point out their duty in every particular case that comes before them." That was true in equity, Hamilton was saying, as it is in law. In other words, he was saying that equity isn't as dangerous as the Anti-Federalists had feared. It wasn't the Wild West. It wasn't open for people to do whatever they wanted to do. Instead, there was a body of law well-developed that constrained judges. Justice Story, who was writing in the 19th century, took a similar tack in his famous treatises on equity jurisprudence. He began his treatise by rejecting this idea of unbounded equity power. An unbounded power, he said, that would be capable of freeing itself from all regard to formal rules and precedents. Because if, in fact, equity were to be so gigantic in its sway, it would amount to the most formidable instrument of arbitrary power that could well be devised. And Story went on to invoke a memorable criticism of equity's arbitrary nature. If, in fact, equity was as gigantic in its sway as Story was positing, a court of chancery might well deserve the spirited rebuke of the English jurist John Selden. For law we have a measure, and we know what to trust to. But equity is according to the conscience of him that is chancellor. And as that is the larger or narrower, so is equity. 'Tis all one as if they should make the standard for the measure the chancellor's foot. What an uncertain measure that would be. One chancellor has a long foot, another a short foot, a third an indifferent foot, and it's the same thing with the chancellor's conscience. So Alexander Hamilton and Justice Story are hitting on the same theme here. The equity jurisdiction is not a way of smuggling Solomon onto the federal bench where he can dispense justice as he sees fit. As much as we might admire Solomon, he would not make it through a confirmation hearing if he described his judicial philosophy as going forth to do justice, deciding cases consistently with his conscience. The equity jurisdiction Hamilton and Story were assuring people was instead a body of rules and precedents. History, tradition, and precedent are what checks the federal court's equity power. That might sound abstract, so let me give you an example. Cases involving the bounds of the federal court's equitable authority don't exactly crowd the Supreme Court's docket, hence the very first symposium on the federal equity power. But consider this one. This is a dispute between, I'm going to describe the dispute between the majority and the dissent in a case called Grupo Mexicano, which the court decided in 1999, back when I was a law clerk at the Supreme Court. So this case involved a dispute over the debts of a failing Mexican company. And the details are not important. For present purposes, all you need to know is that the plaintiffs, who were investors in the company, asked the trial judge for an unusual form of relief. They asked for a preliminary injunction that would prevent the company from transferring assets that could be used to satisfy the debts. The company argued the federal courts lacked the equitable power to issue this relief, and they took the case all the way to the Supreme Court, which ultimately agreed with the company in a divided decision. Now, notably, all 9 justices agreed that history did not directly support this kind of injunction. It was a new kind of relief, and it did not have, there was no precedent of it being traditionally awarded in equity. For the majority, that was the end of the story. As Justice Scalia explained in his opinion for the court, the Judiciary Act authorized federal courts to exert traditional equity power as it existed at the time of the founding. And because equity courts undisputedly did not issue this kind of injunction then, the federal courts lack the power to do so now. There might be competing policy arguments for and against the value of such an injunction, such a powerful new form of relief, But the court disclaimed the authority to do, in Justice Scalia's words, what amounted to crafting a nuclear weapon of the law in the name of equity. By contrast, Justice Ginsburg's dissent rejected this static view of the equity power, and she emphasized the flexibility of equity to reach a just result. Although equity courts had not traditionally issued this kind of preliminary injunction, Justice Ginsburg said this just might reflect a reduced historical need for that kind of urgent relief at a time when debtors could not dissipate assets as quickly as they can with modern technology. The dissenters would have approved innovation to achieve what seemed like the practical and fair result in light of these changed circumstances. So the dissent would have honored the principles of traditional equity, but at a much higher level of generality than the majority. This case, the disagreement between the majority and the dissent, reflects again the old tension between law and equity. When you read the opinions in Grupo Mexicano, you see Justices Scalia and Ginsburg just repeating the theme that we just heard in the readings that I read to you from Justice Story and Alexander Hamilton. All are striving to reconcile the existence of the equity power with the otherwise limited power of Article III courts. And if this dispute about history and its role and restraint on the one hand versus flexibility on the other, static law versus evolving law, if that all sounds familiar to you, it should, because it's the same dispute that we see in a context that's probably more familiar to you, the context of constitutional interpretation. So let's turn our attention there for a moment. It's no secret that judges and scholars differ today on the right way to interpret the Constitution. I want to focus on one aspect of that debate between two schools of thought that I'm just going to call pragmatism and formalism. On one side, pragmatists tend to favor broader judicial discretion. They interpret the Constitution at a high level of generality that leaves judges more free. There's more room to move to pursue justice and the broad purposes embodied in the document. Think of it as a kind of equitable interpretation. The selling point for this approach is that it better equips judges to find practical solutions to problems than does a methodology that risks being wooden, i.e., one that focuses more on the text and the history of the provisions. My colleague, Justice Breyer, is a prominent advocate of this approach. On the other side are formalists, like my old boss, Justice Scalia. And formalists tend to seek constraints on judicial discretion. And they favor methods of constitutional interpretation that demand close adherence to the constitutional text and to history and tradition. Weighing things differently from pragmatists, formalists believe that the dangers of judicial willfulness exceed the dangers of judicial woodenness. And they point out that the court's exercise of judicial power would not be legitimate if it merely imposed the judiciary's own value choices in constitutional cases, or worse, if it pretended to have a theory of constitutional interpretation but was actually just following its own conscience. So, as I said, this is a debate with which you in the room are likely familiar. Formalism versus pragmatism, originalism versus the living Constitution. It goes under different names. But what I want to emphasize for present purposes is something that you might not have noticed before, and that's the echo of equity. So as we just discussed, the debate between equity supporters and equity skeptics is about the virtues of flexibility and fairness on the one hand, and the virtues of the rule of law and constraint on the other. It's a debate that we seem to be unable to escape in the Anglo-American tradition, given that it's been going on since the rise of the Chancery Court in England. In fact, Brutus, in Anti-Federalist number 80, anticipates this debate about constitutional interpretation, and he ties it to, appropriately enough, the grant of equity jurisdiction in Article 3. Brutus says that this grant of jurisdiction will do more than just enable federal courts to sit as courts of equity in the traditional sense I was describing a few moments ago. Brutus says that this jurisdiction, this equity jurisdiction, is going to tempt courts to treat the equitable power as enabling them to explain the Constitution according to the reasoning spirit of it without being confined to the words or letter. And unsurprisingly, Brutus did not welcome this potential development. He thought that the risk of the court's embrace of this kind of equitable jurisdiction would aggrandize judicial power and inhibit the people's ability to rule themselves. Given that tie, actually, to the grant of equitable jurisdiction in Article 3 in the debates about constitutional interpretation, I think it's fair to say that we can consider the debate about the federal equity power to be the sister of the debate about constitutional interpretation. So what, if anything, can the former tell us about the latter? I'll offer you this thought. When Americans ratified the Constitution, they rejected the king and his chancellor too. The grant of equity jurisdiction in Article 3 does not create new chancellors. Representatives of the king's conscience, say, sitting in the Southern District of New York or on the United States Court of Appeals for the 11th Circuit. That is why, as Justice Scalia said in the Grupo Mexicano case that I just described to you, federal courts exercise the equitable power as it existed at the time of the founding. Equity jurisdiction gives federal courts access to a body of law. It does not empower federal judges to be lawmakers. So too with interpretation. The point of the Constitution and its system of separated power is for the people to govern themselves, and federal judges have only the power that the people have given them. In matters of interpretation, that means fidelity to the text that the people adopted. To stray beyond that, even in the interests of flexibility and fairness, oversteps bounds that simply did not constrain the English chancellor. And this foundational point is one on which judges of all interpretive stripes agree. Last term, the Supreme Court unanimously held in a case called Terry versus the United States that the petitioner, Mr. Terry, was not entitled to the benefit of a statute that was designed to retroactively fix the crack cocaine disparity. And Justice Sotomayor, who would certainly place herself more on the pragmatist than the formalist side of the interpretive divide, had this to say in a concurrence. There is no apparent reason that career offenders like Terry should be left to serve out sentences that were unduly influenced by the 100-to-1 crack cocaine ratio. Indeed, the bipartisan lead sponsors of the First Step Act have urged this court to hold that the act makes retroactive relief broadly available to all individuals sentenced for crack cocaine offenses before the Fair Sentencing Act ameliorated that disparity. Unfortunately, Justice Sotomayor says, the text will not bear that reading. Fortunately, Congress has numerous tools to right this injustice. So where the text is clear, everyone agrees that judges' hands are bound, that judges don't have the ability to step in and always ameliorate unjust results or unfairness. In that passage I just read, you note that Justice Sotomayor concludes by saying that Congress had the ability to remedy the injustice. That's where the remedy lies, not with chancellors, but with Congress, because judges have no authority to override the law in the interest of justice. Now, while formalists and pragmatists agree on this foundational principle, they don't always agree on how it applies in individual cases. And that's why there's a debate about constitutional interpretation. That's why you've heard of it and are familiar with it. So in particular, formalists and pragmatists disagree about what the text permits or requires in particular instances. Pragmatists, seeking more flexibility in the law, tend to interpret at a higher level of generality where judges have more room to move. Formalists, and I'll put myself in this category, emphasize text and history in the interest of emphasizing fidelity to the rule of law. Now, the justifications and critiques for these competing schools are beyond the scope of this lecture. but you're going to hear them over the course of law school. And as you weigh them, I encourage you to think back to the debate about the equity jurisdiction of the federal courts. There will be individual cases in which you will long for a chancellor, at least if that chancellor sees the world as you do. And so you may desire to make the law as flexible as possible to let the chancellor in. But what if the chancellor doesn't see the world as you do? Is that discretion really what you want federal judges to have? The Constitution does not create chancellors, and its dictates cannot be measured by each judge's conscience. As the famous critique goes, what an uncertain measure this would be. For one chancellor has a long foot, another a short foot, a third an indifferent foot, and it is the same thing with the chancellor's conscience. I began with images of some of the great lawgivers who appear in the friezes in the Supreme Court courtroom. And I'm going to end by leaving you with the image of two larger-than-life statues that appear outside the front of the Supreme Court at the top of the steps. To the left of the entrance sits a female figure known as Contemplation of Justice. The statue's sculptor, James Earl Fraser, described this figure as a realistic conception of what I consider a heroic type of person with a head and body expressive of the beauty and the intelligence of justice. This statute reminds me of equity. To me, this statute represents our law's aspiration to fairness and justice. To the right of the steps is a male figure known as the authority of the law, or guardian, or executor of law. Fraser, the sculptor, described this figure as powerful, erect, and vigilant. He waits with concentrated attention, holding in his left hand a tablet of laws backed by the sheathed sword, symbolic of enforcement through law. And the Latin word for law, lex, is inscribed on the tablet that he holds. This statute reminds me of law. We want both in our system. And most often, the law itself is what delivers justice. But when it doesn't, it's up to you as the people to change it. Law and equity sit the steps of the court, as they do in the law books inside it, both present, sometimes pulling in opposite directions. That is all that I have for you today, but I welcome your questions.
As Aisha indicated at the outset, there are cards for you to submit questions, and I will put your questions to Justice Barrett. We received an anonymous question that goes as follows. If equity could be shown at the time of the founding to include the power to craft new remedies, would that make Justice Ginsburg a better originalist in Grupo?
I might invite Professor Bray to come up and answer that one. Well, I think that is the dispute. That is the dispute between Justices Scalia and Ginsburg in that passage. It's about whether the grant of equity jurisdiction includes a power to reason by analogy to innovate, or simply to take the body of law as it existed then and not innovate and leave innovation to Congress. I guess I won't weigh in on which would be the better originalist, or if Justice Ginsburg was necessarily trying to be an originalist in that sense. But I think it's always difficult, it's always a challenge to try to figure out the right level of generality at which to read the history. And I will confess that I didn't choose to be the clerk who worked on Grupo Mexicano for a reason. If I had known that I would find myself delivering a lecture that was relevant to Grupo Mexicano today, I would have thought, why on earth did you agree to that? Because it seemed to me very technical and arcane at the time. So.
Okay, well, let me ask you a technical question then. So another anonymous question asks, if equitable discretion can cause variances among circuits, do you think that this is a harm or a benefit to our federalist system? And then let me add, what is your view about national injunctions imposed by district court judges?
Okay, so I'll take a pass on the national injunction question, because that is one that could come before me. Dean Cole, you're making me feel like I'm in front of the Senate Judiciary Committee. On the question of splits between circuits, I will say that I think most of the splits between the circuits that might result from what we think of equitable discretion, I would think arise more often in the context of interpretation rather than this narrow technical category of equitable jurisdiction. Because obviously there are different philosophies, but even those who are practitioners of the same methodology of interpreting statutes or constitutional provisions will not always reach the same result. And there's one thing about which I want to be very clear. Even though Americans have always had anxiety about judges having too much discretion, and even though now our debates between, people who take various approaches to the equity jurisdiction, like say Justices Ginsburg and Scalia and Gruppo, or people who debate about which is the best way to interpret the Constitution or statutes, concern about discretion is present in those, but no one would maintain that discretion is absent from the business of judging. It's an inherent part of judging, and that's just inescapable. So judges aren't automatons. I mean, it's not like AI, at least to this point, has replaced the job of judges. So discretion is always present, and no one should, or if they ever tried to tell you differently, I have some, land to sell you too. Discretion is always present in judging, and where there is room for judgment and discretion, there will be disagreement, and hence we have things like circuit splits.
Okay, we have a question from a law student, Joseph Graziano. Chancery allowed for the development of new remedies. Chancery allowed for the development of new remedies as the need arose. And this seemed to be necessary for the exercise of equity. How limited is federal equity power to traditional remedies?
Well, I think that's the dispute in Gruppo. And so what the majority held in that case is that it was limited to the traditionally available remedies. And as I understand it, and I want to be clear that I'm not an expert in the federal equity jurisdiction, that when I was a professor, that wasn't my particular area of expertise. So I do encourage you to ask, others who do have expertise, like Professors, Bray and Miller, and attend some of the panels at the symposium today. That is the dispute between Justices Scalia and Ginsburg. The majority held that it was limited to the body of law that existed at the time that Article 3 was ratified. And I think the reason for that, the theory of that, would be that, as I said before, Article 3, in granting equitable jurisdiction, did not create chancellors. It gave federal courts access to a body of law. And remember that in England, the Court of Chancery, as I said, that the Lord Chancellor was the king's conscience. There was no separation of power. The Court of Chancery was an arm of the king, an arm of the executive. And the American system is obviously different. We have a system of separated powers. We have independent courts. And so in our system of separated government, even though federal courts have access to this body of equitable law, equitable rights, equitable remedies, we also have Congress as the primary engine of developing rights and remedies. So I think it would be inaccurate to try to characterize federal judges as similarly situated to chancellors.
So we have another anonymous question. Is state sovereign immunity formalist or pragmatic?
Straying from the federal equity power. Let's see, I think state sovereign immunity, that's a complicated question because when you look at the 11th Amendment, I mean, those of you who have taken federal courts know that it's an intensely complicated area because it cannot all be derived simply from the text of the Constitution. And so some have argued that, in fact, state sovereign immunity is not originalist, or that it is not a textualist, not faithful to a textualist interpretation of the Constitution or an originalist account of the interpretation of the Constitution. Others obviously disagree with that and say that, the Constitution was ratified against a backdrop of sovereign immunity. So I think you would find no clear agreement on that point. I think it would depend on who you asked, and it probably wouldn't be a compliment if people described it as pragmatist.
A question from Professor Julian Velasco is, does federal equity require a particular jurisprudential theory?
No, the federal equity power plainly exists because Professor Velasco didn't. Well, Professor Velasco, I'll answer your question anyway. The federal equity power plainly exists by virtue of the grant in Article 3 and in the Judiciary Act of 1789. So it's present regardless.
So you don't have to submit questions under your own name, apparently.
It could have been much better than that if somebody pretended to be Professor Velasco. You could have gotten more creative.
So I'll ask you another anonymous question then.
Okay.
So a lot of the questions want to know about your career and your personal experience.
That's fine.
So one of the questions is, how did your experience clerking on the Supreme Court prepare you to become a judge and then ultimately a justice?
I think of it as an apprenticeship. So in clerking for Justice Scalia, I spent a year, and Judge Silberman, for whom I clerked on the DC Circuit before that, I spent a year at each of their elbows, watching how they did the job, how they ran their chambers, their process for thinking through a case. And so I guess, because I'm a mom and I think about these things in these terms, those of you who are parents, or one day if you become parents, you might think about the fact that your own parents become the model against which you reject or adopt things. Like you say, I like how they did that, I don't like how they did that, but that's kind of the baseline of what you know. And I think in some respects, the judges for whom I clerked were that baseline for me. They were the only people who, up close and personal, I got to see the practice of judging. And so that was the model, and I don't do everything exactly the same way in the way that I run my chambers and the way that I think through cases, but it was my opportunity to see how the process worked. And I will say that it was incredibly valuable to me when I began to at least have a working knowledge of how the inside of the court worked. I read the biography of Justice O'Connor first, which I recommend to you. It's a really great book. One of the things it describes is when Justice O'Connor began at the court, there were just reams and reams of cert petitions of the paper just dumped at her chambers. And nobody told her what to do. Nobody told her what the process was of working through cert petitions. And her task, if I feel, when I feel sorry for myself for the learning curve and getting up, I just think about Justice O'Connor, who that was, the first time she had been on the inside of the building, and running in chambers, and no one was around and no one was helping her. And so there's certainly a lot that I've had to learn, and a lot has changed since I was a law clerk, but I feel like knowing some of the vocabulary and having some exposure to things like the cert pool and cert petitions has at least made it slightly more manageable.
We've got another anonymous question about the transition from being a circuit court judge on the Seventh Circuit to the Supreme Court. How is that different? How is your life different as a Supreme Court justice?
In lots and lots and lots of ways. I would say that in the main, the bread and butter of the job is the same. You're reading briefs, and you're thinking through cases, and you're writing opinions. There are many other things about the Supreme Court's docket and the way that it works. Cert petitions being an example, emergency applications being another, that are not things that you confront on the Court of Appeals. I think the biggest changes are the context in which all of this is happening, in which you do the cases. As a circuit judge, the courts of appeals have mandatory jurisdiction, and so not every case is one that people were watching. There's no like Seventh Circuit blog like there is SCOTUS blog, picking apart every case on the docket. So I think the visibility of the cases and feeling like, I'm learning a new job. It's like learning to ride a bike with everybody watching you. I think that the being a public figure is a lot to get used to, and it's a pretty big shift. I mean, from being, a law professor and then a Seventh Circuit judge, and then, being very much in the public eye is a big shift from my former life or when I was in this building every day. It is a big shift. And that's also a shift from the time when I clerked on the court. I think that's just, the internet did exist when I clerked at the court, but social media did not. And I think just the rise of the use of the internet for the consumption of news and social media, judges and justices' pictures are much more out there. When I was clerking at the court, I was once in the Great Hall where tourists walk through and there are displays, and I was with a friend who clerked for Justice O'Connor, and Justice O'Connor herself was in the main hall. And a tourist went up to Justice O'Connor and asked her for directions. Absolutely no idea that they were talking to Justice O'Connor. And I think that would be much more likely today. It's just much more difficult to be anonymous just because of the dissemination of pictures everywhere. So I have found it difficult to get used to that aspect of the job.
So there's a related question that asks, your published opinions are now have an immediate national audience, including many, many people who are not trained in law. Does that change the way you write opinions?
That is a very interesting question. I tried to write my opinions to be accessible when I was on the Seventh Circuit as well, because even though they didn't have a national audience, they had the audience of the people, of the litigants before me, for whom the case was important. And so I wanted to make them as accessible as possible, to those who were interested in the case, interested parties in the case. I mean, the reality is that legal concepts can be difficult to make accessible to non-lawyers, so there's only so much you can do if you're talking about ERISA. So I do try to make them as accessible as possible within the limits of what you can do when you're just talking about the law.
So it was very powerful when you said that the ratification of the Constitution rejected the king and the king's chancellors. One question here asks, you said that Article 3 did not create chancellors. Is the chancellor's role as the king's conscience relevant to the president's executive power under Article 2?
That is not a question that I've thought about before. I think I would revert to what I said before about the blending of power in the English system and its separation in our system. It shouldn't be relevant to the executive power insofar as we might think of the Chancery Court as exercising a judicial power, because the judicial power and the executive power are not intertwined in our system. However, one obvious way in which the executive can temper the harshness of the law is through pardons. And so I think we could look at that and say that even though there is no Chancery Court that the executive controls as the king once did, the executive has a powerful tool at his disposal for softening what can be a harsh result in the law.
So a second-year student asks, is it relevant that the equity power in England developed against the backdrop of a sovereign parliament as opposed to a system with an entrenched constitution?
Yes, of course that would be relevant, because I think that the soil in which equity grew up, like when you transplant it, it's not an even match because our system is so different. We don't have a parliamentary system, and we have separated power. And so I think to really understand equity, that's why there's so much history involved in equity. To really understand equity, you're diving deep into that system, but I think you always have to remember that the transplant can't be one-to-one because our systems are different.
I have a question here from an anonymous questioner. I'm afraid to ask it, actually.
Professor Velasco again.
I'm not even sure you should answer this. So the question is, do you read SCOTUS blog or do your clerks?
I am well, let's see. I have not ever talked to my clerks about whether they read SCOTUS blog. I would be surprised if most of the law clerks in the building did not. I have a policy of not reading. I read news. I'm not an uninformed person, but I have a policy of trying not to read any coverage that addresses me. I mean, I kind of generally want to know about the court. But I do try not to read, like, whether they're positive or negative. I think it's not a very good idea to read and consume media that's about me because, I think there are personal and institutional reasons for that. The institutional reason is that judges have life tenure so that they can be insulated from fear of public opinion. And so to read criticisms of the court, I think undermines that. So, you shouldn't be playing to anyone in the public or any kind of constituency, being happy if you make one segment of the public happy or, reluctant to anger another. And then on a personal level, it's just not good to have any of that in your head. Certainly not if it's critical and mean, but even if it's high praise. I mean, like, why should you be reading a steady diet? Or in my case, it wouldn't really be a steady diet, but why should you be consuming, flattering, articles about yourself? Because on a personal level, I mean, the day that I think I am, better than the next person in the grocery store checkout line, is a bad day. So I would say that I really try to bracket and put aside, anything, to the extent that I can avoid reading it if it addresses me in particular.
So there are two related questions. One from Isabel Olasinski that asks, how did Notre Dame Law School, and specifically its Catholic mission, impact your career as a lawyer, a judge, and a justice? And then the related question is, what does it mean, as our motto says, to be a different kind of lawyer?
Let's see, I think what Notre Dame does really well and what is distinctive about Notre Dame's mission is that it aims to educate the whole person. You learn law, students, in the context of a community of great concern, that has great concern for one another. Dean Cole was telling me some remarkable stories about different things students have done for one another and others in the greater university community last night. And I think that there is a great temptation, and you see it in the legal profession when you look around, to become very self-focused, very focused exclusively on ambition and on one's career to the expense of other and, let's face it, more important commitments in your life, to family, to your faith, to the common good. And so I think that to the extent Notre Dame accomplishes instilling in each of its graduates, including in me, the sense that your career is one aspect of your vocation, that law is just one piece of your life, and that you take it and you pursue your career as part of contributing to the common good, contributing to society, to doing, your part as lawyers to contribute to the enterprise of seeing justice done. I think that Notre Dame, being a different kind of lawyer, produces those different kind of lawyers because that is the focus of the school.
So there are a bunch of personal questions that want to know what it is you miss about South Bend, what it is you miss about Notre Dame. I don't even want you to answer that question because you're welcome to teach here as long as I still have the keys to the dean's office. So, but what is it that has changed about your life since moving to Washington? What is it you miss about South Bend and Notre Dame?
Oh, I miss so much. When I was here in August teaching, I had only been away. We had only just moved. And so it's a little bit different. Now this is the first time I've been back since August. And it's just painfully clear to me. I was telling Angie Cole last night, it's, painfully clear to me how much I miss the community here, how much I miss, the friendships, I miss the law school, and, the friendships that I had in the university committee and in South Bend. I spent time with a neighbor yesterday from my old neighborhood, and I think there's a richness of relationships that my husband and I had, and our children in South Bend, that are facilitated by the size of South Bend. Despite South Bend's drawbacks, I think it's a great place to raise a family and to develop relationships with other families. And that's just a little bit different now. It's also a little bit different. I like being at Notre Dame and in South Bend where people knew me before I was Justice Barrett. It's now when I meet people, it's under kind of different circumstances. So I'm very much glad that you're willing to have me back at any time because I do very much miss my life here.
And then one last question, again, personal. It refers to the fact that you're the first justice to have school-age children. What is your life like having school-age children while you're on the court?
Well, first woman. So Justice Kavanaugh has school-age children, and when the Chief Justice started, he had school-age children. Not sure about anybody else. I'm sure there probably were others too. I am the first woman with school-age children. Well, I was telling a friend recently that I feel sure that the other day before I came into court, I was the only one of the justices who was listening to the Encanto soundtrack in the car. The only one who was walking into the courtroom with Bruno, no. So I think the demands on my life and the ways in which I am pulled and, the entertainment and media which I consume are different than the average colleague of mine. But, I think there are advantages to that, too. I think I have a different perspective just because I'm seeing a different slice of life. So, it's certainly challenging. In South Bend, one of the virtues is if you're a two-working parent family, everything is close, and so you can zip back if my kids had a pediatrician appointment or if somebody got sick at school. None of that is as manageable there. Fortunately, my husband is currently working out of our home, so he has a little bit more flexibility. So it's challenging. They won't be young forever, and so even though it's challenging, I enjoy it, and I'm trying to treasure the time when they're still young.
Well, I want to welcome you home and thank you so much for this.
Thank you. Thank you.